Hello, everyone. Thank you so much for tuning in to Immigration and Jobs Talk Show. This is Nipasa Pradhan, and I'm going to be with you for this next hour on this very amazing webinar that we're going to have today with none other than our guest. And before I tell you who's it going to be, I have this very important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, once again, friends, welcome back to Immigration and Jobs Talk Show. I hope you are just as excited as I am because it's going to be an amazing session today. So, without further ado, please help me welcome our guest for today's webinar, none other than Attorney Prashanthi Reddy. Thank you so much, Prashanthi, for joining us. How are you doing?
I'm good, Nipasa. How are you?
I'm good. Kind of missed you for the past 3 weeks. We couldn't have these
Yes,
webinars.
yes,
Yeah.
I missed you too. I was traveling. I was traveling, so yeah.
How was how was it all? I mean, the 3 weeks of travel, and I'm glad
It
you're
was
back
good.
though.
Yeah, it was good. Spent time with family and also got some work done, so it was good.
It's lovely, lovely. So it's super great and very relevant a topic we are going to discuss today, friends. And that is if you've gotten H1B RFE, here's how to handle it like a pro. And of course, none other than attorney Prashanthi Reddy is going to help us navigate through all these different struggles and obstacles that have come your way with your H1B. So thank you for joining us wherever you've joined us from. We are streaming live right now on YouTube, LinkedIn, and Facebook. Once again, thank you. And feel free to make this a very interactive session. So, friends, whatever questions you have regarding your H1B RFEs, please drop them in the comments and we'll be very happy to take them later in this webinar. All right, so Prashanthi, I think very, very timely this topic is. What do you have to say? What can folks out there expect from this webinar from us today?
Well, yes, it is, as you said, very timely, Nipasa, because a lot of folks have filed their H1B because of the lottery, and we are seeing RFEs come in. So this is a great session for you to kind of understand how to respond to an RFE if you get it. Even if you haven't gotten it yet, maybe you will get an RFE. If you don't, that's great. It's good to have information on this topic anyway, so that it can help you sometime in the future. Or if you have a friend who maybe got an RFE and has questions, you can help them as well. So we'll be diving into how to deal with different kinds of RFEs and some do's and don'ts when you do get an RFE. And also, of course, we'll be answering questions from the audience. And I'm sure because it's such a hot topic that we will have a lot of questions.
Yes, we will. I can already feel it. And big hello to Krishna Manohar. Thank you for your first comment and thank you for joining us. Saying, hi, ma'am, I received RFE request for my H1B application. So, Krishna, we would love to know more regarding your what is it? What is your RFE about? Please feel free to comment and we will take it up a little later. Stay with us, all right? Okay, so Prashanthi, I'll move on with my questions. I have this first one. How should employers respond to H1B RFEs targeting wage level inadequacies, where a level one wage RFE led to a denial despite the specialized role?
Right. So a few years ago, we did have issues with people using level one wages and USCIS rejecting it and sending RFEs and denials for level one wages. And then, we started getting RFEs, but we were able to get cases approved even with the level one wage. So basically, the premise of the RFE was that it's level one, so it's entry level, therefore may not be a specialty occupation. But USCIS has kind of misconstrued the entire definition of what a specialty occupation is. So it really doesn't matter what the wage level is. Even if you're an entry level position, if you're working, say, as a software engineer, it's still a specialty occupation because the specialty occupation goes based on not which level you're working in, whether it's entry level or intermediate level or a higher level, but it's based on the job duties and the job title as well. They both go hand in hand. So for a software engineer, even if it's a level one wage, maybe it's an entry level position, that does not make it, ineligible for a H1, and neither does that make it not a specialty occupation. It's still a specialty occupation because based on the job description, a software engineer, if you look at OOH, Occupational Outlook Handbook, which is, a document or a book written by the Labor Department, it says that a specialty occupation is an occupation that requires a bachelor's degree in a specific field. And specifically for a software engineer, it says, all software engineer positions require a bachelor's in computer science. It does not distinguish between level one, level two, and level three. So they try to make this into, try to deny level one cases by saying that since it's entry level, we don't believe that, a bachelor's degree in computer science is required for this position. So we basically responded to these RFEs by showing how the wage level was calculated. And basically, we showed that it's entry level, therefore because no experience is required or very little experience is required. And we showed that, skills are required. So there's a point system as to how USCIS or the Labor Department decides on which level to use. And level one is, entry level, and there's a point system. So if it's 1 point, then it's level one. If it's more than 1 point, then it's level two, level three, etc. So there's a calculation, there's a way to calculate it, and then we had to show them the calculation, and we showed them that, how it's level one. So as long as you know what the calculation is and you know how you reached that level one position, and as long as you can show that the job only requires, that, level one positioning, and it's entry level, etc., then you can easily overcome any kind of RFE or RFE that you have, and it should not result in a denial. But of course, if you're using a level one position for a person who has 10 years of experience, say, it's USCIS may not believe that the position that you're offering is an entry level position because the person is really experienced, has 10 years of experience. So why would they accept a entry level position with a lower wage, right? So that's something that then you need to show maybe from the end client that it's an entry level position requiring only a bachelor's degree and no experience, or maybe just 2 years of experience. So if you're able to show that, fine. So there can be some factors, like I said, based on which USCIS may not believe that it's an entry level or a level one position. Employers also sometimes use level one positions when it's not a level one position, so that's something to keep in mind. So as long as we don't misuse, what is level one, level two, and level three, we can definitely use level one positions and then expect to get an approval as well.
Thank you so much for those clarifications. I think it's much required to know whether it's which level it is, especially. So thank you so much for making us more clear with your explanation. Thank you, Prashanthi.
You're welcome.
Now I have this next question. This is regarding specialty occupation. So regarding specialty occupation interpretations, how should petitioners address RFEs related to degree specialization mismatches?
Right. So I guess the question which you're asking, I should explain that for our audience as well, what that means. So to back up a little bit, what is a specialty occupation? Specialty occupation is an occupation which requires a bachelor's degree in a specific field, right? So again, I'm going to take the software engineer example. A software engineer is a specialty occupation because as per the Occupational Outlook Handbook, which is a publication of the Labor Department, you can go online and check it out. A software engineer, for example, requires a bachelor's degree in computer science. So therefore, since a bachelor's degree in a specific field, computer science is required, it is a specialty occupation. So that's what a specialty occupation is. And unless it is a specialty occupation, you cannot file a H1. So that's the premise for a H1. It has to be an occupation requiring a bachelor's degree in a specific field. In other words, it has to be a specialty occupation. So in instances where, say you're filing a H1 for a software engineer again, but the person doesn't have a bachelor's in computer science, so there's a degree mismatch. Say the person has a bachelor's degree in electronics engineering, and you get an RFE saying that doesn't look like the person qualifies because they don't have a degree in computer science, which is what is required by the industry and as per the OOH for a software engineer. So how do you address those kind of RFEs? And they're very common RFEs. And we're talking about some of the common RFEs now and how to respond to them. And this is one of them. Specialty occupation is one of the most commonest RFE that you will receive nowadays, as to how the person qualifies and whether the education qualifies or not, etc., etc. To get an evaluation done, if it's a foreign degree, that's another common RFE. So if you get an RFE where that there's a mismatch in the degree, then how do you address it? One way of addressing it to show that there is no mismatch, that the electronics engineering degree is related to computers, is related and closely related to computer science, and there are many subjects there which are computer science related, and then you list submit the transcripts, list the subjects that you feel are related to CS or the job of a software engineer. And if they see that there are 32 credits, that is equivalent to a major in computer science, then you can address it that way. You can also get an evaluator to look at the transcripts and then give a major in computer science based on their reading of the transcript. In addition to that, or as an alternative, you can also get a work experience evaluation done. So you can use the electronics engineering degree, use his previous experience. If the person has experience in the computer science field, use that experience. So 3 years of experience is equivalent to 1 year of college degree, 1 year of college. So you can correlate the two and get the evaluators to show that the person has a bachelor's degree in information systems. So that's another way to address the mismatch. So these are a few ways that you can overcome these kind of RFEs where the person may not have a degree, or may not appear to have a degree in a related field.
Right, right. Thank you so much. That was very nice an explanation. And absolutely, friends, there could be many instances where maybe your line of study was a little different, but your work line is a little different. But it's always possible to evaluate your skills and experiences. So I think thank you so much, Prashanthi, for showing us the way.
You're welcome.
And let's move on. I'm still looking. Oh yes, Krishna Manohar has responded, so I will definitely take it up. Should we take it up? He was the first person who commented, so I think we should just quickly
Sure.
take this one
Why not?
inside it.
Yeah,
Yeah.
sure.
So Krishna Manohar, hi to you on YouTube, is asking. I was asked to produce all companies' offer letters. However, I do not have experience letter from one company. How to handle the request?
So we would need more information. Why is USCIS asking for detailed experience letters and offer letters? It could be that it's the same thing that we just discussed. Maybe you don't have a degree that's related to your field, and maybe your employer wants to get a work experience evaluation done, and therefore, they need detailed experience letters. You don't need to submit experience letters from all your companies if that's the reason for the RFE. I'm just guessing. Most probably, you would only need experience letters equivalent of 3 years to show that you qualify. As long as you have a bachelor's degree in engineering, say, and you are trying to get the equivalent of a bachelor's degree in computer science, then you'd need an experience letter for 3 years. You don't necessarily need all your experience letters. So if you don't have one, as long as the one that you have is 3 years or more, you should be okay.
Okay. I hope you can figure out, and maybe if you want to tell us more about yourself, Krishna, or your line of work, maybe that way we could help you more. I mean, with more exact answers, but I think this would be the case. So maybe they need it for evaluating. So thank you so much for participating and for your comment. And I hope that you figure out how to go about it. Thank you. Moving on, I have this next question, Prashanthi, and that is, when facing an H1B RFE regarding a specialty occupation, what best practices should be followed, and which documents should be prioritized to demonstrate the role's specific requirements and industry standards?
So when you are responding to RFE based on specialty occupation, you always have to show that it is, there are many ways of showing that your particular job is a specialty occupation requiring a bachelor's degree in a specific field. One of the ways is, of course, just the easiest way is quoting the Occupational Outlook Handbook. But generally, if the Occupational Outlook Handbook is explicit about the requirements and it says that a bachelor's degree in a specific field is required, then you don't usually get an RFE for specialty occupation. And if you do, there's a very easy way of responding. You just quote the specialty occupation, right? So you just quote the Occupational Outlook Handbook. But in some instances, maybe the Occupational Outlook Handbook will say a bachelor's degree in engineering is required. So then USCIS might say that for that position, it's not a specialty occupation because they require, it's not a specific major, it's engineering, which is a broad major. So USCIS might then say that it's not a specialty occupation. So then we have to then, the onus is on us to show that it is a specialty occupation and that a bachelor's degree in a specific field is required by the industry in general and by the employer previously when they hired, if they hired people for the same job previously. So many the ways of showing that it's required in the industry is, other than the OH, is of course then you take out printouts from DICE or Monster or other job site portals and show that commonly required, for say a software engineer again is a bachelor's degree in computer science. So that's one way of showing it, a printout of job site portals. Another way, as I said, is to show that you previously hired people in this job. So you would submit their W-2s, you would submit their degree copies, and you would say that, look, we hired software engineers before, and this is the degree copy. We've always hired someone with a computer science degree. So that's one way. Another way of showing it is to get an expert opinion letter saying that, the evaluator, who's usually a professor in that field, believes that, that particular position requires a bachelor's degree in a specific field, say computer science. So that's another way of doing it. You could also, show that your website, that you had a job posting for the same job and you required a bachelor's degree in computer science for this particular job. So these are some ways of showing it. Also, you can show that, whether the industry requires it or not, you require it because the job description is so complex from another regular software engineer job that a bachelor's degree in computer science is required for your particular job. You could show that you in your case you're following an exception to the rule. For that, you have to show the complexity. You have to show off the job. You have to describe it. You have to explain why a computer science degree is required in your particular job and it may not be required in other jobs. You have to show how your degrees or your job description is different from the regular job description. So complexity of the job is one way of showing it by giving an explanation of the job and maybe producing a table which has job description on one side and what particular major is required or what subjects are required to perform those duties, and then show that you have those subjects through your transcripts. So that's another way of putting everything together. So these, I think, are some pointers if you get RFE on specialty occupation.
Okay. And you were saying W2, you mean wage level 2, or what is it?
Our W-2 is something that's given in the US for an employer when they work. An employee is given a W-2. That's proof that the person worked as an employee.
Okay. Okay. Thank you so much for clarifying. And Krishna Manohar is back. I think we should take up the rest of his concern. He's saying, I have Bachelor of Engineering and Science degree, computer science and engineering, 4 years degree, and 16 plus years of experience. So he had firstly asked, like, the company is asking to produce all offer letters and detailed experience letters, and he doesn't have one experience letter from one company. How to handle the request? Do you think that if
Yeah, I
he
don't
gets
understand. Yeah, I don't understand, Nipasa, why they're asking if he has a Bachelor of Engineering and Computer Science and Engineering degree, and if it's a 4-year
Mhm.
degree, they should not be asking for work experience. So I really don't know why the employer is asking for it. I think you should get a copy of the RFE to figure out what they actually need and respond accordingly.
Exactly. And he received this RFE for his H1B application. So I think it would be best to consult an attorney, Krishna Manohar, because your case seems to be a little, I mean, you have
I,
provided everything
yeah,
already
I think
and
there is
still,
not enough information as to why the experience is required if he has a bachelor's degree in computer science. So I think he
exactly.
needs to delve into that further to see what the RFE is actually about so that you can actually, give your employer the right information. Sometimes employers don't know what to ask for or maybe misinterpret the RFE, or there might be something in there that I'm not aware of. So I think in order to answer your question, I need to see a copy of the RFE.
Yes. So, Krishna, Prashanti's details are also scrolling under the screen. Yes, you can call her on this number, 212-354-1010. You can even email Prashanthi at reddyesq.com. Please check the spellings before you email her. And you can also visit this website, www.reddyesq.com, to get to know more about Prashanthi Reddy and the law offices of Prashanthi Reddy. Thank you, Krishna Manohar, and I really hope that you can figure out how to go about it. And hi to all you folks. So sorry, we were so much concentrated on Krishna's questions. We've been wanting to resolve it, but we will take up each of your questions. Vikas, Sahil, please stay with us. And for now, Prashanti, I have another question. And this is, how have recent trends in USCIS adjudications impacted H1B cap exempt petitions, especially within sectors like healthcare and education?
The recent trends in the USCIS adjudication of H1B cap exempt petitions. Okay, so we're talking about cap exempt. Um and obviously, the lot of cap exempt petitions are in the healthcare and education because the just taking a step back, who is a cap exempt petitioner? So when I say cap exempt, it means you don't have to file under the cap. So even if the cap is over, you can still file your H1 anytime during the year. You don't have to register for the lottery if you're a cap exempt petitioner. Now, who is a cap exempt petitioner? It could be institution of higher education, like a university. It could be a hospital that is related to an institution of higher education, like a teaching hospital, uh, or it could be a nonprofit research organization or a government research organization. So these are, folks, these are petitioners. So if your company is one of these, falls under one of these brackets, then you're cap exempt. Yeah, so USCIS has been um, quite strict with reference to cap exempt petitions in both the healthcare and the educational sector, and also in the research sector. For example, recently we received an RFE for a nurse that we filed for a hospital. It was a teaching hospital, and they wanted to know, and they don't usually ask this, but they asked in this particular case. Um, Not only did they want to see proof that it is a nonprofit institution related to an educational institution. So we did submit the contract between the university and the hospital to show that there was a contract whereby the hospital was providing internship opportunities to students at the university. And that's pretty common for them to ask that. And we submitted that even when we filed it, but they still asked for it anyway. But also another interesting thing is that they asked how the duties of the beneficiary are related to this relationship between the university and the hospital. How does his duties help to, help with this, help with uh, the the university, internships, right? So I said that there was a contract between the hospital and the university that the hospital would provide internships. They wanted to know how this nurse would help with the interns, and that's unusual, right? Because it's not necessary that the job should be related to the purpose of the organization. But they said that, and they don't usually do this, but they said that it has to be related. So you have to show that the nurse was involved in training these interns. So that's an example of how USCIS is taking these RFEs to the next level and asking for more information than they usually ask. There was another RFE in which the petitioner was, in fact, a research organization, nonprofit research organization, and we did submit all the information showing that it's a nonprofit organization. We submitted the tax documentation, and we also submitted the website information showing that they are conducting research work. But USCIS again was not happy with the information submitted. They sent an RFE asking for more proof that the major chunk of work done by the organization is research work. So we had to submit that, and of course it got approved. But just another example of how USCIS is kind of pushing back on cap exempt cases, especially in the healthcare and the education sector.
Right. I think there is stricter scrutiny, and folks out there, this is what's happening. So I think how maybe Prashanti, if you could tell folks out there how can they avoid these RFEs, maybe at one go, if there's any chance, how can they make
Well,
sure their documents are
right,
on the dot?
right. So submitting as much documentation as possible is will help. Sometimes employers will submit bare minimum documents, and USCIS requires more. So submitting all the
Mhm.
documents that you have related to cap exempt, related to the fact that you're cap exempt, will help. And submitting this, in the initial stage itself. But sometimes, as I was giving you with that example, we did submit the documents, but they sent an RFE anyway. But so in some instances, you can't avoid an RFE because that's random. So you just have to produce as much documents as you possibly can in the initial stage and then hope that you don't get an RFE. And if you do, then you can just remind them that you already submitted the documents that they had requested for if you don't have anything
Yes.
further to submit.
Right, right. So, friends, I would just say, when you get an RFE, don't get disheartened because it is just request for more evidence, and you just need to prove that. And it's not a denial, it is not a rejection. So don't lose your hope and get on to how you can prove better. All right. And I think we should take a break quickly. And soon after the break, we will also take up the questions from viewers out there who have been actively commenting and participating. Thank you so much. Please stay with us. Ishita, good to have you. Good to have your question as well. And also, if you feel free, I mean, to contact Prashanthi Reddy, attorney Prashanthi Reddy. You can go visit her website, reddyesq.com, and you can call her on this number, 212-354-1010, and email her at prashanthi@reddyesq.com. And don't go anywhere, friends. We are going to talk more about H1B RFEs today. But right now, we'll just go for a short break. On Immigration and Jobs Talk Show, this is Nipasa Pradhan. Welcome back, everyone, once again to this second half of this webinar we are having on Immigration and Jobs Talk Show with Attorney Prashanthi Reddy, our guest for today, on this topic we are having, and that is about H1B RFEs. So, thank you so much, friends, for joining us. And we've already taken up some questions. Yes, so if you've gotten H1B RFE, here's how to handle it like a pro. And maybe each, not maybe, I'm sure each case is different. Your RFEs will be different. So tell us more about it in details. And we are here to take up your questions. Thank you, Prashanthi. It's been really nice so far. You've been answering each of our questions with so much details. It's really nice. All right, so I have this next question for you, Prashanthi. If an individual has a pending H1B petition and receives an RFE, what strategies can be used to maintain employment authorization while awaiting a final decision?
So it depends if it's extension and you've received an RFE on your extension, then if your I-94 expires, you could still work for 240 days. And after that, you can still remain in the country, but you have to stop working. So there is within, the H1B regulation, there is a law which allows you to continue working for a certain period of time, even if your I-94 has expired. So I guess the best way to avoid a long processing time is to, if you see that it's taking longer than expected, then you should convert your H1 to premium processing, then they will respond within 30 days.
Okay. Thank you. Thank you so much for taking that up, Prashanthi. And I think we are going to take up more questions from the audience, but quickly, I'll just say hi to Fagun. Thank you so much for joining us, and also Jose in LinkedIn. We are surely going to take up your questions. Just stay with us, all right? I have this next question, Prashanthi, and this is regarding the most common errors. So, what are the most common errors that lead to H1B petition denials, and how can petitioners proactively avoid these pitfalls during the filing process?
Sometimes H1B RFEs are random. So the best thing would be, if possible, and sometimes they're not because they need, additional documentation. Um, we can often predict, or at least, guess whether the case will be RFE'd or not. Sometimes the job description or job title itself is prone to an RFE, but we have to use it because that's what the job title is, and we inform the employers that it's possible that you might get an RFE if you use this job title, etc., etc. So look at the job title and the job description carefully before you file your H1. Some jobs are just not specialty occupations, and I wouldn't even file. Some are kind of borderline, so as long as you're able to show in the job description that the job duties are complex. Anyway, and the other things that we mentioned about specialty occupation, as long as you're able to show all those, check mark all those items, and even if it's borderline, a job can get approved for a H1B petition. So I would, do research on the job title that you're using before even you start the H1. You can expect also a denial if the person has not maintained their status. If you're filing a change of status or an extension, and clearly either the I-94 is expired or they are on a H1 but they don't have pay stubs, then you can expect a denial in those situations, and you should you should try and prepare for a denial and have a backup plan as to what to do if the H1 gets denied. Maybe while the H1 is still pending, file for a change of status to a B2 or some other status, or leave the country. Um, in some instances, there are instances, as I said, where we're almost expecting a denial. So, we always have to have a backup. And the common errors is, as I said, could be a job, could be the job itself, could be that you're out of status, or it could be that, the case, the LCA was filed wrong, and then they send an RFE, and you cannot then file a new LCA. You cannot make amends and correct the LCAs, and then in that case, the H1B will be denied. For example, if the LCA was filed for a wrong work location, and the work location is actually a different one, then there's nothing to be done there. The H1B will simply be denied. You have to refile. That could be another reason, not filing the LCA correctly to start off with. In other instances, the H1B can come back. It's not a denial, but it's rejected in the mailroom. This happens if it's not signed, if the checks are incorrect or written wrongly. You know, the, so that's a reason why, or it's sent to the wrong address. Then the H1B petition can come back. It's not a denial, but it's rejected at the mailroom. So these are some instances in which a H1B petition can be denied.
Thank you. Thank you so much, Prashanthi, for taking us through them. And these are some of the common ones. So, friends out there, I hope this has been resonating so far, so good with you, this webinar. And please don't forget to like, share, and subscribe to our content. And of course, subscribe to our channel. And thank you so much. Moving on, I have this next question. And
We
Prashanthi,
should,
for
Nipasa,
individuals,
should we, sorry to interrupt. Should we just go
yeah.
with the questions? Because we have a bunch of questions from the audience and we are
Okay,
running out of
sure.
time. Let's do that and then come back if we have,
All right, all right.
if we have
Let's
time.
do that then. So let's go ahead with this first one. This is from Fagun. Hello, ma'am. I just need to ask one thing. I will be filing my H1B today, and I need to verify whether using an employment verification letter is acceptable instead of an offer letter, or if I need to provide both.
Um, Either one is fine. The offer letter or an employment letter, either one is fine to file a H1B. USCIS really doesn't care what you use. They're looking at other things, so this is not really, I would say, as important as some other things that we discussed. But by all means, use either the offer letter or the employment letter. It doesn't matter. As long as the offer letter, remember, whatever you're using, it has to have correct information in it. Otherwise, don't use it.
Mhm.
Better not to have either if the information is wrong, because then there'll be discrepancies in the wage, in the job title. So just make sure that there are no discrepancies with the information provided in your offer letter and the LCA.
Yes. So all information must be correct. And thank you so much, Fagun, for your question. All right, let's move on to Joe's. This is on LinkedIn, so I don't know if I'm pronouncing it right. Hello, I would like to immigrate to the USA,
Jose
and he has
hasn't
a.
said anything else, right? Oh, okay, he has
Oh
said.
yes,
Okay, EB2.
I heard. Yeah, EB2 visa just to start. Which is the difference to this one? I don't understand much.
It's
If you
not
can
clear,
crack
so we'll wait
this.
for Jose to clarify what his question is.
Yes, Jose, please make it more clear. What is it that you're trying to ask? A difference between what and what? And um, yes, thank you. Thank you for your question, though. Okay, let's move on. Move on to maybe he's asking the difference between H1B and EB2.
Well, EB2 is a green card, so you have to apply for a labor cert and an I-140, and it takes time to get the green card. And then you can directly immigrate to the US. The priority dates have to be available. A H1 is a
Mhm.
non-immigrant petition, and it's faster to get a H1, and then you can apply for your employment-based category to green card once you come in on a H1. So they're two different things. One is a green card, one is a non-immigrant petition.
There you go. They are very different, Jose. And thank you for your questions and for participating. Let's move on now. Let's move on to Sahil. Or Ishita. Ishita first, yes. I received an RFE for my H1B transfer specialty occupation last week. With premium processing, the 15-day deadline is looming. My consultancy hasn't communicated with me, and I have no direct attorney contact. How should I approach my consultancy to expedite the response? Is a week's silence normal, or am I justified in pushing for urgency?
I don't think you're justified, but I do understand that you're anxious. There is no 15-day deadline. I don't know what 15-day deadline you're talking about. Usually, USCIS to respond to an RFE will give you 85 days. And as long
Mhm.
as you respond before that and they receive it before that deadline time, you're fine. It can be responded at any time. RFE is usually, takes time to respond to it because you have to write it properly, a response. So, the attorney will, especially if it's a specialty occupation RFE, it does take time to prepare the memo and get all the documentation. So I would say not to rush it. 1 week is hardly enough time to respond.
Yes. There you go, Ishita. Thank you so much for your question, and thank you, Prashanthi, for taking it up. All right, let's move on to this next one. This is from Vikas on YouTube. My H1B cap visa petition received an RFE with a deadline of September 18th, 2024. My previous attorney claimed to have submitted the response by September 13th, but no update on USCIS case status. No FedEx tracking number provided. Attorney unresponsive. Employer verified with USCIS. No response received. Can can I, number one, send a late submission with a new attorney?
Um, I wouldn't presume that it was not submitted, but I would feel more comfortable, of course, if there was a FedEx tracking number showing that they received it on time. Um, USCIS doesn't usually accept late responses. And you could try and say that you had a reason for submitting it late, to use the nunc pro tunc, which is the catch-all phrase for anything that, you're requesting USCIS to do something which they usually will not, on humanitarian grounds. You could do that as well. Yeah, if there's would be, it's better to try and get a tracking number to see if they've received it or not. Or maybe call USCIS. Your employer certainly can, to find out if they've received the RFE response. That
Mhm.
might be, a good way of doing it before you actually send out another response to USCIS.
Right, right. Well, she has more questions. He has more questions. The next question is request USCIS acceptance despite expired deadline. And question three is file a complaint against the previous attorney. Please advise on next steps and potential outcomes.
I think we kind of discussed it. Call USCIS first, or open a status request to see if it's been sent. We're presuming it's not sent. See if they've received it. Um, if they haven't, if they say that they haven't, then you'll have to file a late response and take your chances with a nunc pro tunc request on humanitarian grounds. And you can also mention that the attorney was supposed to send it out with all the proof, of course,
Yes.
and they did not, and it was not under your control, and you tried your best to maintain your status, etc., etc. So that can definitely be done.
Okay. But Prashanti, is this kind of a thing common? I mean, fogging up a person with, I mean, there is no information on the whereabouts of the application itself.
Well, it's difficult because USCIS does not update its case status information promptly, especially after an RFE. They don't necessarily, update the RFE received kind of response.
Mhm.
So you wouldn't know unless you have a FedEx tracking number and you see that it's been delivered, or you're able to, chat with Emma on USCIS website, or call someone and, find out if they've received it or not.
Right, right. But on the part of the attorney, I mean, it's totally not right, I think, to be unresponsive. So I really hope that you can have a word with your attorney, Vikas, and all the best. I hope this gets resolved as soon as possible. Thank you for your question, and thank you, Prashanti, for taking it up. Let's move on with this next question. This is a follow up from Fagun. Thank you. Since I work remotely from home for my company and its client, do I need to provide an itinerary in I-129, a space available in initial section, part 9? Thanks.
Um, since I work remotely from home for my company and its client, do I need to provide itinerary? Oh, so an itinerary requirement is not there anymore. After the IT serve versus Cessna case in 2020, USCIS has agreed that they will not ask for an itinerary, so you don't need to in any circumstances.
Okay. There you go, Fagun. So thank you again, Prashanthi. Let's move on now to this next question. This is from Sahil. I'm currently on H1B visa and approaching the 6 year limit. My I-140 is approved, and my employer filed a premium processed extension, which received an RFE regarding employer employee relationship.
Oh, okay.
I think that is it. The next is the RFE. The RFE response was submitted with a payroll confirmation valid only for a short period. If my extension is denied, what options do I have? And can I refile before my I-94 expiration?
Yes, you can definitely refile before your I-94 expiration. You should convert the case to premium processing if you haven't already, so that, in premium processing, they usually respond faster after you send the information. It's rather unusual, I must remark, that they're asking for employer-employee relationship because they are not doing that anymore. So it would be interesting to see this RFE to see that they are again going back to asking for employer-employee relationship. But I'd be interested to see this RFE really, to see what they're actually asking for, if it is indeed employer-employee relationship, because there haven't been, sending any RFEs on that particular subject.
This is interesting. Um, I mean, are there any chances you are related, maybe, Sahil? Or tell us more. And if you could actually provide, or best thing, maybe why not just have a one on one consultation with Prashanthi? Maybe you could email her with your RFE or something. Yes, thank you so much, Sahil, for participating. And thank you, Prashanthi. Now let's move on to the next question. This is Roshni, also on YouTube. I have received an RFE for my H1B extension. Not sure if a 15-page RFE is the normal these days. It's very detailed. Asks about my employer has control and asks
Well,
about how my employer has control and supervision over the beneficiary.
very interesting. So this is a second employer-employee relationship kind of RFE that we're seeing in this call, right? Very interesting. I haven't received any RFEs that related to employer-employee relationship. If you do, then you should ask your attorney to respond saying that they're not supposed to ask this, and it's based on the, again, IT serve court decision in 2020. Um, so the response should, that's what it should be. You should not be even submitting documents showing employer-employee relationship or right to control, etc. You should
Okay.
basically remind them of the decision and then the agreement that followed with USCIS. So there's a memo that USCIS has published where they said that itinerary is not required and they will not be asking for the employer-employee relationship anymore. So just print out that memo and submit it as a response to this RFE.
Okay. So there were further questions. Why the position is a specialty occupation in the first place? And if it is, then how does my mechanical engineering bachelor's fit into it? Or how does my 10 years of experience equate to the skills required for this position? RFE received within a week after premium processing upgrade. I-140 approved 1 year ago. H4 and H4 EAD extension submitted altogether. What do you suggest? So you still
Well,
suggest the same thing?
yeah, obviously you have to respond to the RFE. The specialty occupation part of it, of course, you have to give a detailed explanation as to how your degree is related, and if it's not directly related, then get a work experience evaluation done, submit
Mhm.
proper experience letters, which show progressive experience, and that would be one way of showing. Then, if hopefully you have related experience, then you should be able to get a bachelor's in, the field, in the related field, and then that would be one way of responding to the RFE.
All right. All right. Thank you so much, Roshni. And I hope that you've got your answer and you know how to go about it. And thank you so much, Prashanthi, for directing Roshni. And I think we have taken up most of our questions for now. Just quickly going through. All right. So, anyway, I have another question for you. And this is, for individuals transitioning from F1 to H1B status, what specific issues commonly trigger RFEs and what documentation can strengthen their cases?
Yeah,
F1 to
for
H1.
so change of status from F1 to H1, we usually get RFEs asking if they have maintained their status. It's very common to get an RFE asking if they've maintained their F1 status. If they're presently students, then they will send an RFE usually asking for whether they're going to school, whether there are any classes online or they're going in person, proof that they're actually going to school, letters from their school, I guess their transcript, proof that they've paid the fee, proof that they're physically attending classes. So these are common questions that they ask if you are presently in school. If you're on an OPT, or uh, if you're on an OPT, then with STEM or post completion OPT, then they might ask questions of as to whether you maintain status on an OPT, whether you if you're post completion OPT, then if you worked, even if it is as an intern, you're allowed to work for unpaid. If it's STEM OPT, then it has to be paid, so that you worked for the necessary number of hours and proof of that. So the pay stubs and the experience letters, etc. If you are on CPT, then they will ask why you got onto a CPT, why CPT was required, is CPT required by the school? How quickly did you, if you got onto a day one CPT, is that why did you do that? Then the school has to show that maybe they have an executive type program where, experience and classroom instruction is given simultaneously, requiring them to get CPT immediately. So these are a few questions that can be asked, when you're filing for a change of status from an F to a H.
Thank you so much, Prashanthi. And at this moment, we have Arjun on YouTube asking, my I-140 petition received an NOIR citing inconsistencies in my education credentials. I have submitted each and every document that I had. Now, what further should be done?
Yeah, this could be a problem with the way the labor cert, the perm was filed. Perhaps it was filed, um, yeah, I don't know. Perhaps it was filed with some other educational credentials, or require the requirement was, a bachelor's in something else, and you don't actually have that bachelor's. So it really depends on what the issue is. I can't really give you advice unless I, take a look at the RFE. But I'm hoping that you are able to overcome the inconsistencies. Otherwise, the I-140 will get approved and denied, and then you might have to just refile the labor cert also, if because the inconsistencies come not from the I-140 but will come from the labor cert.
Right. So thank you so much, Arjun, for your question, and thank you, Prashanthi, for taking it up. I hope you got your answer, Arjun. If you have further questions, you can keep commenting. We'll take them up quickly. And last but not the least, Prashanthi, I have another question. And if can an H1B employee switch from a cap subject to a cap exempt employer after receiving an RFE or NOID? And what legal considerations should guide this transition?
Well, if yes, you can always be in a cap exempt, work with a cap exempt employer at any point of time, um, because they're not subject to the cap, and you don't have to file a registration or get approved in the lottery. But the question here is when you have a pending H1, can you switch to another H1? And you'd have to file the other H1 based on the receipt or based on your previous status. So if you're previously on F1 and say you filed a cap subject H1 and you think that it might get denied or you don't want to work for that employer, then you can always file for a change of status from your F1, which is your original status, to a cap exempt employer. So F1 to H1, change of status again. Because until the H1 is actually approved, you're not on a H1. So you would be continue to be on an F1 as long as you're maintaining your F1 status. So yes, you could do that, but in some instances, maybe you're on cap gap status, meaning your F1 has actually expired, but it's artificially extended because of the cap gap law. In which case, then you have 60 days to go back to an F1 status, maybe taking additional courses, filing an OPT, whatever it might be. And then once you're
Mhm.
in an F1 status, then you can again file for H1 cap exempt at any point of time.
All right. Thank you so much, Prashanthi, for the detailed explanation. And I think it's time now to wrap up our show. But before we go, Prashanthi, if you have any end notes for folks out there who are dealing with H1B RFEs right now, and if you could just uplift them with some hope, maybe.
Well, yeah, as you said earlier, Nipasa, H1 RFE is not a big deal. They're asking for more information. And in most instances, H1Bs, RFEs, after there's an RFE, it gets approved as long as you respond to it correctly. So I would say get proper legal advice when you get an RFE, even if you have filed the application yourself. When you're responding to an RFE, I would say, especially if it's complicated. And sometimes it's
Mhm.
difficult to know that it's complicated. It seems simple enough, but there may be something that you have not understood that they're asking for and you don't respond to that. So I would always say, I think, get an attorney to respond to uh, the RFE, and it should get approved.
Absolutely. Thank you so much. And folks out there, if you're looking for an attorney, why not contact attorney Prashanthi directly? And her details are on the screen. You can call her on this number 212-354-1010 and email Prashanthi at reddyesq.com. And you can also go check out www.reddyesq.com. Thank you, Prashanthi, for joining us. It was lovely having you after 3 long weeks, and I'm hoping to see you again in the coming week.
Yeah, hope to see you next week again and with a more
Me too, me too.
equally interesting topic. Yep. So see you again.
For sure, for sure. Thank you. And folks, feel free to keep commenting because we can take them up in the next session as well. So thank you so much for joining us. And it was really lovely to have you participate with your questions. And in case you're watching this after the stream has ended, you can always keep commenting because we have our experts and we keep having these amazing webinars, very informative and enlightening, where we can always get back to your questions and to you. And feel free to also email me and call me. This is also my WhatsApp number, just in case you are more available on WhatsApp. This is my number 408-335-6444. And my email address is nipa@hirightpeople.com. And also go visit www.hirightpeople.com to get to know more about us. Thank you for watching. Y'all out there have a great day ahead. And absolutely don't forget to subscribe to Immigration and Jobs Talk Show, not just on YouTube, but also on Facebook and LinkedIn. We are there as well. All right, bye bye for now. And thank you once again. This is Nipasa Pradhan signing off.